intelligence officer, but also a fighter and for freedom and for our Constitution. I really appreciate all that he's been doing to speak truth to power. My name is John Bonifaz. I am, as Matt opened up, an attorney. My focus for this panel is not in connection where I am right now with Free Speech for People, but I will say that I do view this whole question of war powers as a basic democracy question. I certainly agree that when it comes to war, we have to deal with the impact that it has on our Constitution and our democracy. And I want to just tell you how I got into this question of war powers. I was listening to a radio show that comes out of Boston called On Point. It's a national show. Some of you may have heard it. And in October of 2002, just after Congress had passed a resolution that it claimed authorized the war in Iraq, there was a conversation happening on Point about whether Senator Robert Byrd was right. And as some of you may remember, Senator Robert Byrd made the argument repeatedly in the rush debate leading up to the passage of that resolution that this was an unconstitutional delegation of power to the executive branch, to the president. That Congress and only Congress had the power to determine whether or not to start a war, whether or not to declare war. And this resolution effectively handed to the president, then George W. Bush, the decision of whether or not to start a war. And so the whole hour discussion was, was Senator Byrd right? And they had a Stanford law professor, expert, presented on the radio show about this, and the ongoing discussion was happening. And then somebody called in and said, well, why doesn't Congress just declare war? And this Stanford law professor says, well, that's essentially what they've done. And I thought, no, that's exactly why we're having this debate. They have not done that. And I think, somebody ought to test this in court. We ought to take this matter into court and figure out how they declared war. So I then set out to try to reach Senator Byrd. I thought Byrd v. Bush would be the best way this could proceed. He didn't prevail in the Senate and on the floor of the Senate and Congress, but now he should go to the judiciary, our third branch of government, and figure out, is this in fact a properly declared war? So I was reminded by somebody that I actually I knew Ken Hackler. He's, as some of you may know, a former Secretary of State in West Virginia, has also been in Congress, and I reached out to him, and I remember it was President's Day weekend, and I said, Ken, I had this idea. I'd like to get to Senator Byrd because I think he should sue the president over this whole question of this resolution. Before the war starts, we should take this into court. And he liked the idea too, so he connected me with Senator Byrd. And I ended up having, the following Tuesday, right after President's Day, a conversation with the senator in which he asked me a lot of important questions about ripeness. Would this be ripe? We hadn't yet begun the war. He asked me about standing. Who would have standing? Do members of Congress really have standing? I said, if you stood up, Senator, we would gather members of the armed forces because they have been found in Vietnam War era cases to have standing after a series of fights. And he asked a lot of good questions. He seemed quite interested. He said, well, I want to think about this, and let me get back to you at the end of the week. Then a couple days later, I got a call from the Senate counsel's office. And this woman called me up, and she said, I understand you've had a conversation with Senator Byrd about some litigation that you'd like to conduct. I said, that's correct, but that was an attorney-client privilege conversation. I'm not interested in having a conversation with Senator McConnell and other people. You represent the full Senate. I wanted to talk solely with Senator Byrd. She's like, oh, I can assure you this will remain fully confidential between you, me, and Senator Byrd. And then, she asked what was the litigation and everything. And suffice it to say, I never heard back from Senator Byrd. So then I actually backed off. I said, well, if Senator Byrd, who was so vigorously opposed on the floor of the Senate to this resolution, if he is not willing to sue, then who will be willing to sue? But then on New Year's Eve day, 2002, then President Bush held one of his infamous press conferences on his ranch in Texas, which effectively lasts a couple minutes. He was weeding, and some reporter in these 2 minutes shouted to him saying, "Mr. President, it appears that we are going to war." And he yells out, "That's not for you to decide, that's for me to decide." And I thought, no, that's not for you to decide either. I'm going to sue this guy. So I then...
Don't piss John off.
I then set out to go a different route. I said, you know, let's first gather members of the armed forces, let's gather military families, and then let's go to the House side, to members of Congress on the House side, Congressman John Conyers Jr. and others, who possibly would then stand up. And so we assembled this coalition, and I invited some other lawyers, including my father, who's an attorney, to join in on this. And we identified members of the armed forces. Military Families Speak Out, many of you may know, is a very important network of military families that have been standing up to stop this war. They helped us gather military families. And then we went and we had 12 members of Congress, including Congressman John Conyers Jr., lead this fight. And we went into court, and we sued in February of 2003, on the eve of the war, suing then President Bush and Donald Rumsfeld, arguing that this was not a properly declared war or anything of equivalent action. Now, just to go into this further in terms of what Congress did, I think it's first important to bring back the words of Elbridge Gerry that Ben has referenced before Elbridge Gerry. No, I think that he said something very important on the day of August 17, 1787, when the delegates to the Constitutional Convention turned their attention to war. And by the way, I'm reading from a book that I ended up writing about this case called Warrior King, the case for impeaching George W. Bush. The question had come to the convention that day: how would this nation, this new nation, go into war? You know, how would war to be declared? And Pierce Butler, a delegate from South Carolina, sought to grant this power to the president, arguing that, quote, he will have all the requisite qualities and will not make war, but when the nation will support it. And Elbridge Gerry, a delegate from Massachusetts, rose to object. He said he, quote, never expected to hear in a republic a motion to empower the executive alone to declare war. His objection carried the day. Article 1, Section 8, Clause 11 of the Constitution makes quite clear that Congress, and only Congress, shall have the power to declare war. And the framers of the Constitution understood the reasons why. Jefferson talked about his desire to create, quote, an effectual check to the dog of war. George Mason said that he was for clogging rather than facilitating war. James Wilson, speaking at Pennsylvania's ratifying convention, stated, "This system will not hurry us into war. It is calculated to guard against it. It will not be in the power of a single man or a single body of men to involve us in such distress, for the important power of declaring war is vested in the legislature at large." Several years after the adoption of the Constitution, James Madison would write these words: "In no part of the Constitution is more wisdom to be found than in the clause which confides the question of war or peace to the legislature and not to the executive department. Beside the objection to such a mixture to heterogeneous powers, the trust and the temptation would be too great for any one man." That is the history of how we got the War Powers Clause into the Constitution. And then we need to go forward 2 centuries later to that debate on the floor of the U.S. Senate, the U.S. House in October 2002. And to frame that debate, I want us to imagine for the moment that the United States Congress were to have passed a resolution which states the following: the President is authorized to levy an income tax on the people of the United States as he determines to be necessary and appropriate in order to pay for subsidies to U.S. oil companies. No amount of legal wrangling would make that constitutional. Article 1, Section 8 of the United States Constitution grants the power to levy taxes solely to the United States Congress. And were such a resolution to emerge, it would have been knocked down in the courts. Now let us turn to reality. In October 2002, the United States Congress passes the resolution which stated, quote, "The President is authorized to use the armed forces of the United States as he determines to be necessary and appropriate in order to, one, defend the national security of the United States against the continuing threat posed by Iraq, and two, enforce all relevant United Nations Security Council resolutions regarding Iraq, as he determines to be necessary and appropriate." Mr. President, you decide. You decide, based on whatever evidence or whatever lies you have, you decide whether or not to take this nation into war. We, the United States Congress, will effectively delegate to you that power. That is really what Congress did in 2002. And I think Senator Byrd, as much as he did not agree to sue, I think his words that he spoke on the floor of the Senate are historic and will be recognized in history for standing up on the right side. He made it clear. He made it clear that the framers never intended this to be the case. He said, "Mr. President, here in this pernicious resolution on which the Senate will vote soon, we find the dagger that is being held at the throat of the Senate of the United States. I say to my friends, we ought to pause and wonder if Captain John Parker and his Minutemen fought on the green of Lexington for this piece of rag, this so-called resolution. When Parker lost 8 or 10 of his men with that first shot, is that what they died for? This resolution? Is that what they died for? How about John Paul Jones when he was fighting the Serapis? He was the captain of the Bonhomme Richard when he said, 'I have not yet begun to fight.' What was he fighting for? Was he fighting for this piece of cowardice here in this resolution that gives to the President lock, stock, and barrel the authority to use the military forces of this country whenever he will, however he will, for as long as he will? We are handing this over to the President of the United States," Senator Byrd continued. "When we do that, we can put a sign on the top of the Capitol, and we can say, 'Gone home, gone fishing, out of business.'" Others stood up, including Congressman John Conyers, Jr., including late Senator Kennedy. But of course, this rush to war and this rush debate was all about these claims of alleged weapons of mass destruction, this mushroom cloud, as Condoleezza Rice spoke about it on the Sunday morning talk shows. And you had people like Senator Kay Bailey Hutchinson standing up on the floor of the Senate saying, "I trust the President." And, again, the history here demonstrates that no matter what kind of trust you may have with the person occupying the Oval Office, that is not the duty of Congress. It is not to just trust the President. It is, in fact, to exercise that power or not. And Congress completely shirked its duty. We filed this case in federal court in Boston. We went before a judge, Judge Toro, who happened to have 30 years prior heard a case about the illegal bombing of Cambodia brought by then Father Robert Drinan and others. And he had summarily dismissed that case. So when we walked into his courtroom, I was well aware of his views on this question, and he was well prepared to knock us out, as he did that very day, with a 3-page written motion that cited one case, which was his case on Cambodia 30 years ago. But nevertheless, we were certain that we were not going to let him have the last word, and the Justice Department was there in force, to argue that they in fact had the the President had the inherent authority to send the nation into war. So their arguments were even way off the charts. But we went to the Federal Appeals Court on an expedited basis. We sought an emergency hearing, and in fact, 74 law professors from around the country filed a friend of the court brief at that appellate court level, and they wrote that, quote, "The exercise of judicial authority here is urgently needed," and compared the case to the infamous 1952 case of Youngstown Sheet and Tube Company v. Sawyer, which, as you may know, is the war powers case in which the Supreme Court intervened to stop President Truman's seizure of the steel mill during the Korean War. The law professors wrote, "It is difficult to imagine a situation presenting separation of powers questions more narrowly and inviting judicial intervention more urgently than does the present case." The appeals court, at least to be fair, actually held a sobering hearing and heard argument for both sides and did not have its decision to hand out the moment the hearing ended, took it under advisement. And this, of course, was leading days up to the invasion, but the appeals court ultimately issued a ruling refusing to intervene on the grounds that the matter was not ripe. And as you may know, this was right around the time, as we were leading up to war, where there was this coalition of the willing who held a meeting on Azores Island off of Portugal, which consisted of the leadership of the United States, then President George W. Bush, the Prime Minister of Britain, and the Prime Minister of Portugal. And they all gathered, the coalition of the willing, the three of them, to just... Spain, I'm sorry, you're right, yes. And they all gathered to decide, in fact, whether or not to invade and whether to pull their efforts from the Security Council at the United Nations to determine whether or not they would just go without UN approval. We had made an alternative argument in this case, not the lead one, but the alternative argument was that even if you accept that Congress had presented an authorization of war, they conditioned it on UN approval. And if you look at what Senator John Kerry said on the floor of the Senate and what then Senator Joe Biden said on the floor of the Senate, they made it clear that the president had promised them directly that he would get authority from the UN Security Council before invading Iraq, and only based on that promise were they passing the authorization. They were quite explicit about that. So based on that condition, we said the condition was not being met. The appeals court said, well, you don't know that yet because they're still before the Security Council. Then this coalition of the willing decided they were going to pull out of the Security Council because they weren't going to get France, they weren't going to get Germany to back them. And once they did that, we rushed back to court and said, okay, well, now the conditions are met. It's pretty clear. The press conference had been set by the president 2 days later. It's pretty clear that we're about to start bombing Iraq, and now the matter's ripe. And this is where the court, once again, like other courts, sadly, simply punted and said, well, there's still not ripeness here because there are other factors that need to play out. There's no direct conflict between Congress and the president. This idea, which the lower court, Judge Toro, had put forward in his Cambodia case, that there has to be a direct conflict between Congress and the president in order for the judiciary to intervene, is completely specious. Because, frankly, that would mean, effectively, that Congress needs to affirmatively say, we are not going to war, right, and directly conflict with the president who wants to go to war, and then the judiciary intervenes. But the default position of the War Powers Clause is that we are not at war. That's our default position. And in order to get us into war, Congress must act. So there doesn't have to be any direct conflict. If Congress and the president are colluding together to violate the War Powers Clause, the judiciary must and should intervene. In this case, sadly, it stayed on the sidelines, and we marched into an illegal war. It is also true that we have seen violations of the War Powers Clause prior to the Iraq War, dating back to the Korean War. And it is also true that we've seen them since. The conflict in Libya is a direct violation of the War Powers Clause. And I want to make clear here, there's a lot of talk about, well, the president is violating the War Powers Act. The War Powers Act, as we know, is a federal statute passed in the wake of the Vietnam War to deal with reporting requirements that the president must make when we are going into war. 60 days, within 60 days a report must be filed. But it does not supplant the Constitution. You cannot amend the Constitution by passing a law. In order to amend the Constitution, as we know through Article 5, 2/3 of the Congress have to pass and send the states for ratification, or you have a constitutional convention. But you don't just pass a statute and that amends the Constitution. So the War Powers Act does not supplant the War Powers Clause. So as much as, yes, it's true that the president is also violating, President Obama is also violating the War Powers Act in this instance with Libya because he has failed to report after 60 days what the basis is for continuing this conflict. The fact is that more importantly, this is a violation of the War Powers Clause because there was never any declared war or anything of equivalent action. So these violations continue, and it really, I think, is incumbent on all of us who believe in the Constitution who believe in democracy and who want to make sure that we do not engage in this unending, ceaseless period of war, that we stand up and fight to lift up that very promise of Article 1, Section 8, Clause 11, which is we the people, through our elected representatives in Congress, decide whether or not to send the nation into war, not any king or queen who happens to sit in the Oval Office.